protection, and we're going to come at it from two different ways. I'm going to discuss the limits of copyright protection, particularly in the area of what I call industrial copyrights, which are very utilitarian kinds of programs that we have in everyday equipment, whether it's consumer or industrial or commercial equipment. And particularly from the point of view of the Digital Millennium Copyright Act, and then two fairly recent decisions that affect that, which are the Sixth Circuit case in Lexmark versus Static Control and the Federal Circuit decision in Chamberlain. Speaking with me today is Sam Byassee, who is a partner in the firm of Maupin Taylor in the Research Triangle Park. Sam and I have spoken many times together on programs. We went through the chairs together of the intellectual property section of North Carolina Bar, and I think Sam came after me 1 or 2 years as the chairman. Sam is also a former chair of the ABA section of Science and Technology. Sam will speak on the limits of copyright protection more from an open source software point of view and following on the discussions from this morning. What we'll do is Sam will do about 20 minutes on his, I'll do about 20 minutes, and then we figured to have about 30 minutes for just a general discussion, and hopefully that should be the highlight of it, because I think these are some topics which may engender some conversation and dialogue, and we certainly look forward to that being a major part of the program. Sam?
Thanks, Dave. And while I get started here, I'm going to be talking about open source licensing, and in particular the GPL, the GNU public license. I'm not sure you'll need to follow along, but I do have copies of the license down here in this corner if you'd like to walk over and pick one up, because I'll be referring to it several times. I would also like to note, and particularly for those of you who may see this after today, it is in fact 2005, not 2004.
April Fool.
April Fool, that's right. As it turned out, as I was preparing this, I realized that Mark Webick and I actually spoke on a panel exactly 1 year ago today, and some of this material comes from that presentation. So that's why it's a year off. What I want to do is talk about open source licensing. Really, a couple of things, and I'm using the GPL as the as sort of the basis, because it is, I will contend, sort of the basic license, and most other licenses are a little bit more restrictive as far as what you can do than the GPL. But there is a difference between free software and open source software, at least according to the Free Software Foundation, which originated the GNU public license, the GPL. And according to the Free Software Foundation, the FSF, the open source folks broke off about 7 or so years ago, and the open source advocates have a difference of in their worldview, I guess, perhaps like the Catholics and the Episcopalians. But open source, again, this is according to the FSF, views the license and the theory behind this type of distribution as more of a development methodology. The FSF views it more as a social movement. I don't know whether that means the free software people qualify as a religious order or not, but given the fervor with which I have heard some of its advocates make their arguments, I would not. I don't think I would say no. Now, I skipped over one piece. Basically, free software, according to the FSF, refers to what it calls 4 kinds of freedom. Freedom to run the program that you get, freedom to study how it works and to adapt it, freedom to redistribute, and then freedom to improve and distribute those improvements. And as I say, what I'm doing here is assuming that the GPL is pretty much the least restrictive license, and that when I talk about the GPL, that's really a stand-in for open source. And I think that will do for the purposes of this talk today at any rate. And the issue that I really want to talk about is enforcement of the GPL. And obviously, under copyright law, the copyright law grants certain exclusive rights to the copyright holder, the owner. And if one of those rights is exercised by someone other than the copyright holder without the holder's permission, that's infringement. Now, a license, very simply, and this is a quote from Black's Law Dictionary, it's probably a couple of versions old at the moment, but a license is just is permission by somebody who has the authority to provide that permission for someone to do an act without which the act would be illegal. Now, the GPL, or I should say the FSF, contends that the GPL is a covenant. It is not a contract. Now that's very significant because it says what they are doing, or what a distributor of software is doing by distributing that software under the GPL, is to promise that the licensee will not sue under the copyright law for infringement. It's not, again, according to the FSF folks, it's not a contract, which would require, of course, offer acceptance and consideration. Now, if it's a covenant, then what's going on is simply that each copyright owner, in potentially this very long chain from the Free Software Foundation, at least with respect to the GNU version, down to the last licensee who is looking at this license and deciding what they can or cannot do, every previous holder that has modified the software in some way and distributed it has covenanted not to sue the people subsequent in the chain. And I know from conversations with them that the FSF contends it's not a contract. I was looking on the internet for some nice, concise statement of that, and I could not find it easily, but I did find in the FSF on their website a frequently asked questions that included at least the concept of this is not a contract, because they say most free software licenses are based on copyright and they're limited to what you can do. However, some free software licenses, and they then go on to make a distinction between these licenses and the GPL, are based on contracts, and contracts can impose a much larger range of possible restrictions. So I want to at least use that as some evidence that the copyright holder, the FSF, of the GPL, the license agreement itself, contends that it is not a contract. Now, the GPL says very plainly that you're not required to accept this license that comes with the software itself. Since you've not signed it, you've downloaded it, the license is a file in what you have downloaded. There you are, you're looking through it. There's no requirement anywhere to read the license before you start using the software. There is no click wrap version that requires you to accept the license before you have the ability to install and use the software. But you're not required to accept it. However, nothing else grants you permission to modify or distribute. Now notice they don't say use it. They don't say copy it, say from one computer to the other. But nothing else grants you permission to modify or distribute the program, which is the software that you have received, or its derivative works. These actions are prohibited by law, that is the copyright law, if you do not accept this license. Therefore, by modifying or distributing the program or any work based on the program, you indicate your acceptance of this license to do so in all its terms and conditions for copying, distributing, or modifying the program or works based on it. Now, that last sentence is interesting because it starts looking a little bit like the good old elements of a contract, and in particular a unilateral contract. In other words, the GPL license says basically you can modify or distribute it if, and it lists several conditions in Section 2 of the license that you've got to follow if you do that. And it very plainly, in what I just read, says that you indicate your acceptance by modifying or distributing the software that you have received. And I argue there's also consideration there, because you, as the licensee, if you modify it, create a derivative work, and then distribute that derivative work, you are agreeing to incur a detriment. That is, you're limiting your rights under the copyright law in exchange for getting this license. So you distribute it under the terms of the license, you're reducing your right under the copyright law. Well, so what? Well, here is the first issue that I think the FSF and those folks that propound the GPL as the appropriate type of license. The first problem is that the FSF says that it is going to, in the future, and it has very recently said, well, it may take us a little bit longer than we thought, but it intends to modify the GPL. Now, the Free Software Foundation has been very, very unforthcoming, given its definition of freedom, about exactly how it wants to modify the GPL. But it says we're going to do so. It says there are some things in there that maybe aren't completely clear. And you know, in the light of experience now, the current version of the GPL is version 2, which was first published in 1991. So it's been around a while. We've got lots of experience with it. We want to change it. Now, very interestingly, and this is in the header of the recommended header information that the FSF recommends to put in those files that you're distributing under the GPL. And it says, this program is free software. You can redistribute and modify it in the terms of the GNU General Public License as published by the Free Software Foundation, either version 2 of the license, that's the 1991 version, or at your option, any later version. Now that's very interesting. What they're saying is we want to reserve the right to change it, and if you want to, you can opt for this later version, which of course doesn't exist yet. Now, this is a very recent addition to the language. It wasn't in the 1991 version. It has recently been added, I think, sort of as a precursor to them making these changes. And the question is, can they, in fact, change horses in midstream like this? Now remember, we've got this nice long chain of copyright holders, each one modifying what they have received and redistributing it. And you know, at least until recently, no one even realized they had the option of redistributing it under some future version. Now, I would argue that what that means is the copyright holder can't distribute it today and then 2 years from now see the license and say, oh, I like this one better. I'm going to start enforcing this version rather than version 2, which was in effect when I first distributed it. But I think what they mean is in 2006, when version 3 comes out, someone distributing a portion of the code after that time can opt for version 3 rather than version 2. Now the question, and this is really the nub of the issue, because the purpose of the GPL is to make sure, in having to redistribute under the terms of the GPL, is to make sure that those folks down at the end of the chain are distributing versions that are under a license that's just as freedom-loving, if you will, as the very first version. So if version 3 contains a more restrictive term, what happens to all those previous versions that have been distributed under version 2? How does someone at some point in the chain get out from under having to redistribute under version 2? If they received it under a version 2 license, what justifies them in telling others that they can redistribute under this more restrictive version 3? Assuming that version 3 is more restrictive, and I'm getting there. I'm going to get to that in just a moment. So I'm not quite sure how the FSF intends to make this conversion, but they say they will. There may be some connection there between what it says when it says the license is not a contract and what it wants to do here. But be that as it may, whatever problems exist under this non-contract license, as the FSF would like to have it, and their expressed intent to change it in some way in the future. I want to look for the rest of my time, and maybe even a little bit more, at the problem, the very practical problem, and particularly if you are an attorney representing or in-house at a software developer or any large organization that does development in-house, software development in-house, is developers who, I mean, they want to be as efficient as they can be. They don't want to reinvent the wheel. They want to be able to economically reuse software that they might come across whenever possible. So here's management saying, okay, look, we need this new program in 3 weeks. It's got to do X, Y, and Z. It's got to have these features, whatever. And the developer says, okay, now I know that part of this ought to be easy. Part of it is just a matter of crunching out some code. But part of it, I'm going to have to think. I'm going to have to figure out how to do it. How do I maximize the time for that which is going to require a little bit more creativity? And obviously the answer is, isn't there some code that I can reuse? Isn't there some sample, some model that I can just take and plug in at the appropriate spot? And since the GPL mandates that source code be available for any GPL code that's distributed, a light bulb will go on in the developer's head, and they'll say, hey, let me get on the internet. It's a wonderful way for people to distribute open source code. I'll see if there's not something out there that will tell me what I need to do these housekeeping routines, and I'll just incorporate that into my code. Now, the problem is your company going to lose control as a result of some of this open source code getting incorporated into a proprietary program? Is it going to lose control over its code because you incorporate open source into what you're writing? What you're writing becomes, to that extent, a derivative work. And according again to the FSF, you know what I mean, FSF. Now everything is under the GPL, and have you just entered an agreement to distribute all of your proprietary code, or at least the part that is wrapped around that open source code? Have you just agreed to distribute that, make the source code available to anyone? Now, the GPL actually addresses this, sort of. It says that to the extent that part of what you're doing could reasonably be considered an independent or separate work, then you can distribute them as separate works, and they're not under the GPL. However, when you distribute the same sections as part of a whole, which is a work, that is a derivative work from your GPL code, then everything goes under the GPL. Mere aggregation, again, I'm continuing with the license language, mere aggregation of another work not based on the program here capitalized being the GPL code with the program or with the work based on the program on a volume of storage or distribution medium does not bring the other work under the scope of this license. So you can certainly distribute them together without it happening. But the question is, what is, and I italicized, what is a work and what is an aggregation? You know, compilation, independent execution, envelopment, interaction, data exchange, those would seem to be some possible definitions of what constitutes an aggregation. The FSF position is interesting. It talks about libraries and linking to libraries, and it basically says that if your program depends on a non-free, that is a non-freely licensed, a non-GPL library to do a certain job, it cannot do that job in the free world. Again, some of that worldview language. If it depends on a non-free library to run at all, it cannot be a part of a free operating system such as GNU. It is entirely off limits to the free world. So it seems to be saying you cannot use a library that is not under the GPL along with GPL code. Mark, you have probably had discussions about this very issue, and I'd love to get your comments on this a little bit later. But the proponents of this non-linking position in the debate really have not clarified exactly to what extent these links are forbidden. Maybe they're talking about source code before it's compiled into executable code. If your source code links to these non-free libraries so that the executable, the one single executable that you're building is now sort of a mix of the different source code files, that's forbidden. But is it forbidden simply to call an external program that is, or for that matter, a library that is non-GPL? And if you look at both the language of the GPL and the FSF explanations of it, they really seem to be talking about a predominantly open source program that has a little bit of non-GPL, and they really don't talk about this very large proprietary program that may have a couple of routines that from open source land that someone incorporated. Now, the practical thing, I think, at this moment, to the extent that there is much that can be done, is first, make sure when you're out there and you're talking to developers that are working on software, make sure that your developers understand that this is an important issue and it makes a difference. And in some cases, good luck getting them to appreciate that it makes an important difference. But try to get them to understand that it makes a difference whether they're using open source code in a program that your company or your client intends to distribute with a proprietary license. After it's developed, go in and ask those same developers, is there anything here that came from open source? And most of the time they'll say no, whatever the actual truth is, but you've got to ask. And last, and this is really where this issue is going to come up in the real world, is during mergers and acquisitions when you're doing due diligence. You've got to do due diligence on that. because the acquiring entity or the entity that's in control of the transaction is going to use any sort of uncertainty about copyright rights or licensing rights to drive the price down. So you want to make sure that you understand where those potential weaknesses are. And of course, there aren't any cases out there that I'm aware of. I said that a year ago when we did an open source program, Mark, and I'm not aware of any that have come up since then. And I'd love to be corrected if you've heard of any. But thank you very much, and I will turn the program back over to Dave.
Thank you, Sam. Let's switch this around here. We've spent most of the day talking about software and software that doesn't have any question as to its creative nature and its subject matter for copyright protection. We've raised a lot of questions this morning about patent protection, but we've been talking for the most part about software that would not raise issues from a creative content point of view, that would not raise Feist versus rural publications type questions about whether it's something that should be protectable. Let's talk now about what I call industrial copyright, which goes into an area where you may get questions about even part of a claim, either part of a program as to whether that part is protectable. You might get questions in terms of its entirety if it's a very small or utilitarian program. What do I mean about industrial copyright? Well, the use of a copyright by a business entity to protect primarily utilitarian works. And that is often coupled with an intent, not all the time, but certainly in recent years we see very small routine programs, either as lockout devices or very fact-based, very simple mathematical formula programs, maybe not even, should you really even call them a program, just a few lines of code that are used as much as anything, not to improve the functionality, but to gain some advantage by creating a barrier to entry. And we see them all the time in everyday life. Consumer products, office products, all kinds of industrial and commercial applications. And some of it may be protectable, but it may be wound together with other things which are not protectable, or tied together with lockout devices. Copyright, of course, came from much more classical background where there was no question about the level of creativity. And it evolved from maps, books, engravings in the original act to encompass things as other things were created that rightfully belong in the area of copyright. And then in 1976 Act, we moved to copyright protection for software. Prior to that, trade secrets. The first major software case that I was ever tried was actually a trade secret case in the 1970s, because people didn't apply copyright. It was right on the cusp, and by the time we went into the 80s, it was copyright, and now we have patent. But that, while certainly there's a lot of creativity in a lot of computer programs, there's also some things that are pretty mundane. Along the way, we've begun to add on other things that extend the nature of copyright protection, and some of that's come about because of the digital age, some of the need to protect things that should legitimately be protected. And we come to the passage in 1998 of the Digital Millennium Copyright Act, And certainly very important needs were brought to Congress. They responded with this act. But the act, which was aimed at circumvention of technological devices, aimed at protecting from piracy, that sort of thing, of course, got developed into some things of unintended consequences because the DMCA prohibits circumvention of technological measure, effectively controls access to a work protected by copyright. Well, if you can port from an entertainment type situation into a very industrial copyright situation, and you can put some minimal utilitarian, very small, relatively non-creative piece of software in there, and then put a technological device on it, you can begin to build barriers and entry. And is the base work really copyright protected? And is this at all what the DMCA was designed to protect against? No, not really. And what you have, in a sense, is some crisis, whether it's real or perceived, might be in the difference, might be debated about, but certainly to the people in the entertainment industry, it's a very real crisis in terms of pirating. So they go to Congress and they get acts to protect themselves, and they push to have it as extreme as they can. And they're not going to care particularly about what happens in other industries, but as you come along from the continuum from a highly creative entertainment industry all the way down to the other end to a very low-level industrial type application, if you apply some of those things all the way down, you get some very strange consequences. And so people in an ordinary commercial and industrial sense, particularly original equipment manufacturers of anything, began to see ways in which they could use the DMCA to create a barrier to entry. Once again, on all these kinds of products. I mean, you take the automobile, and if you could put something on there, some very low-level thing that you would assert, lines of code that you would assert as a copyright and a technological device and whatever on an ignition system or anything else, say that was not patented or the patent had expired, you patented it in 1983 and that's gone, but now you come on and juice it up with a little bit of code that really doesn't do anything to functionally increase the efficiency of that fuel injection system or whatever it is that you do, ignition system. Hey, you may be able to make sure, if you're the original equipment manufacturer, that there's no aftermarket. Nobody else can make that part because you have a lockout device the way it's tied into the rest of your electronic system. Now, one of the areas that this was done in is in the aftermarket for photocopiers and laser printers. If you ever bought toner cartridges or other aftermarket supplies for photocopiers and laser printers in any volume, you know that that's the area where the original equipment manufacturers try to make their money. Hewlett-Packard or Lexmark or anybody else doesn't make much money, any money on that laser printer that they sell to you. But they want to have the HP or the Lexmark sitting installed so many million units so that people will buy their products in the aftermarket, and then they have high margins on that. Obviously, you have aftermarket recharging business, as it's called, where you remanufacture those toner cartridges, and you may get those for 50% of what the cost would be to buy a new one. It may not really be 100% of the function, but it may be 97% of the function or 95% of the function, and you get it for 40 or 50 cents on the dollar. So obviously, if you're in the OEM business, you want to keep as much of that aftermarket as you can. In that particular industry, certain ones are more aggressive about this than others. HP, and most of the manufacturers sort of take a reasonable position in terms of how much they try to protect from an IP point of view. I think Lexmark would be regarded as the most aggressive, and in fact, that's what has led to one of the cases we'll talk about in a minute. But all of this is really, when you take the DMCA, when you take the Copyright Act, and you got to read it against the policy of what's been said, and certainly in the digital field, we've recognized for more than 10 years you have a need for interoperability. You've got to be able to preserve an appropriate level of competition. You can't have everything turned into a tying arrangement in favor of the OEMs. That's Sega versus Accolade and Computer Associates versus Altai, and a host of other cases. But in lots of areas in the industrial sector, you've had companies pushing and using the DMC, particularly the technological lockout devices and the anti-circumvention measures, to try to control competition in the aftermarket. That's resulted in two fairly recent cases that I'll talk a little bit about, and then we can talk in more general terms about. One is Lexmark versus Static Control Components from the Sixth Circuit, which in fact dealt with a chip on a toner cartridge. Most of the original equipment manufacturers now will put a chip on that cartridge, and the aftermarket has to come up with a chip that's a design around to put on the cartridge when you redesign it. When you remanufacture it. Otherwise, you put the cartridge in and the printer doesn't run. A natural tension there, but Lexmark went to some more extremes from a lockout device point of view. Chamberlain Group versus Skylink was a Federal Circuit case, dealt with garage door opener, aftermarket, an improvement, innovation, control device manufacturer was sued by the original equipment manufacturer. Now, what do these cases say? Lexmark, Sixth Circuit is a little tough to read because it's three judges with three different opinions. But there's a certain amount of synergy between the three different opinions, and I think you can draw some of the following conclusions. One is the technological measure that has been circumvented restricts access to a copyrighted work. That sounds perfectly logical to me, but that's not what Lexmark argued. Lexmark wanted to say that a technological measure that protects a non-copyrighted work and is circumvented, if you circumvent the technological measure, you're still in violation of the DMCA, even though you haven't accessed a copyrighted work. The Sixth Circuit said, no, wait a minute, you're not, the DMCA doesn't give you a separate substantive right. It's still got to have a nexus back to a copyrighted work. And you can't claim that it's a technological measure that's been circumvented if there's another door to the work, which there was in this case on one of the items. The Lexmark court further reconfirmed that brief computer programs, and I'm just talking about a few lines of code, not very much at all, without a creative flair are less likely to be copyrightable. And at some point, just a couple of lines of code isn't creative. It is just it can be just a recitation of facts, as in Feist versus rural public. It would fall clearly in that side on Feist versus rural publications. It may be a purely simple mathematical algorithm, as in using analytic geometry to just call out the points to create a font on the screen for a word processing program. There's only one way to express it, and so you're not going to get copyright protection for that. Next, found that a computer program may be protectable in the abstract but not entitled to protection when used as a lockout device. That at the cusp, they're going to look at that and look at what the purpose is. And third, found that the insertion of a minor arbitrary element, in the Lexmark case it was a stock symbol, into an otherwise functional program would not convert the program, I say functional, that's not correct, it would not give it sufficient creativity. If you've got a non-creative restatement of facts in just a couple of lines of code, by sticking in some arbitrary symbol or word or number in there, that doesn't make it creative, because you're just trying to use it as a lockout. It doesn't raise the level. It's got to have some relationship to the functionality. I was not present at the argument in the Sixth Circuit, but I've talked to a couple of lawyers who have, and one of the things that at least two of the judges were very concerned about was the protection of the aftermarket, that if you pushed all the arguments that Lexmark had put forward, you would in effect, as an example that I said in the automobile industry, you just would create totally extended monopolies for the original equipment manufacturers, as long as they went through the work to try to protect each one of their parts in this fashion. And I think philosophically, this is what was driving the Sixth Circuit. Now, the copyright holder in Chamberlain before the Federal Circuit, and this is the garage door opener case, their arguments included things like the pre-DMCA history of the garage door opener industry was irrelevant in terms of what was meant by implied licenses, of what a purchaser could do with the equipment that they had. Secondly, they argued that it overrode all pre-existing consumer expectations about legitimate uses of the copyright embedded software, that all uses of the products containing copyrighted software to which a technological measure controlled access in conjunction with competing products were per se illegal under the DMCA. Federal Circuit rejected this. Noting that the copyright holder's proposed construction would allow any manufacturer of any product to add a single copyrighted sentence or software fragment to its product, wrap the copyrighted material in a trivial encryption scheme, and thereby gain the right to restrict consumers' rights to use its products in conjunction with competing products, and would allow virtually any company to leverage its sales into the aftermarket as a monopoly, practice that both the antitrust laws and the doctrine of copyright misuse normally prohibit. In Chamberlain, Federal Circuit established that consumers who purchase a product containing a copy of embedded software have the inherent legal right to make certain uses of that copy of the software, and that the DMCA's anti-circumvention provisions establish new grounds for liability in the context of unauthorized access, but do not establish a new property right. And that's consistent, of course, with what the Sixth Circuit said in Lexmark. DMCA prohibits only forms of access that bear a reasonable relationship to the protections that the Copyright Act otherwise affords copyright owners. DMCA makes the circumvention of a technological measure that protects access to a copyrighted work a violation, prohibiting actions that facilitate infringement, but such circumvention is not a new form of copyright infringement. It's just an additional protection, but you've still got to have an underlying protected work, a copyrighted work, and and you've got to be dealing with those parts of it which are truly copyright protected. DMCA does not allow a copyright holder to hold a user liable for the authorized use of the copyrighted material. Burden of proving liability for unauthorized access into the DMCA is on the plaintiff, and the DMCA does not explicitly or implicitly limit the scope of the antitrust laws. All of these things are some things which the holders of industrial copyrights have attempted to maintain. We've got 20 minutes here, and I think we've tried to put some provocative topics out here on the edges of copyright and try to get people to think about some things. And we certainly invite comment and questions. And I told Mark Webbing that I was going to make him the first speaker to comment on it. So hopefully, Mark, you've got some comments or questions for Sam or myself on either of the two topics.
Well, I don't have a whole lot of comments on days. I'm more entertained by what's going on in that area. Some of the things that Sam talked about, I think, certain truisms that I've just come to in working with open source, and especially dealing with the GPL. And one of those truisms is that a non-distributing end user can do anything they want to with the software, and they have never violated the GPL. They can rip it apart, they can put it back together, they can put proprietary software with it and run it any way they want. And Evan Moglen at the Free Software Foundation will tell you, yes, that's exactly right. So even though they've got some quotes on their website that would imply perhaps otherwise, that is in fact the case. There's another area that you had up there that was a good point. I can't think of it right now.
What about where you think they might be going with the version 3.0 coming?
Oh, that was it. It's sort of interesting that this has all become such a hot topic now in the last few months, because I think Evan himself has sort of leaked out that this is coming. Well, in fact, I saw the first draft, or an early draft of the GPL3 in the fall of 2000. So it's been sitting out there a long time. What can we anticipate? One of the part of it is you have to look at the GPL and the history of the GPL. Folks wonder, well, why did they use such arcane terminology to refer to things like derivative works and collective works? Why didn't they call it those things? As Dan Ravisher, who's a good friend of mine, and pointed out recently, when this thing was being written by Richard Stallman with Evan Moglen's help, there were no cases defining what a derivative work in software was. So, it's really rather remarkable that in 1991 they sort of anticipated these areas, didn't know exactly what to call them, but in fact tried to deal with that. So it's a little unfair to them to say now, well, why were you not a little more clear with your language than you were? Well, they were about as clear as they knew how to be at that time. The one area, so I think one of the things you're going to see is maybe clarity of language being improved. Another area will be probably more explicit language around software patents. And then the third area, which I think will be the most controversial for anyone using version 2 right now, is a provision that would say if you are running GPL software in an environment where the others have the ability to use it, in other words, in an ASP type model, then you have to make the source code available to them. That's not going to be real popular. And I sort of understand where they're coming from, but I think that's going to be trying to stretch it a little farther than a lot of people are willing to go. At the same time, I will say, they intend to make it available for public comment, and they will take feedback on it and take that into consideration as they go to try and improve it. And the idea is to try and improve it. One of the things that's out there is that when Linus Torvalds decided to apply the GPL to the Linux kernel around which the Linux operating systems are built. Originally, it just referred to the GPL version 2. When they added the language in there and later versions, he went back and struck that language out, and it just says this version and no later versions. He wanted to be quite clear that if the kernel was ever going to have a change, it was going to be a conscious change, and it would be a change that affected the entire kernel going forward, not somebody's branching of the kernel off and taking it forward. So the Linux kernel is under GPL2 and only GPL2 at this time. And it will remain there until basically Linus Torvalds decides it will be under something else.
Actually, I have a question about that very specific point, because unilateral change by Torvalds would be impossible, since he's not the holder of all the copyrights that of all the various sub-pieces of the kernel that have been developed.
Well, it would certainly be challenging. I mean, what's interesting is in one moment the kernel is probably one of the least clear pieces of code as far as copyright ownership is concerned, and yet there is probably no group that has better documented the change history in a piece of code than the kernel group has. I mean, you can go to www.kernel.org and get the change history on the kernel going back probably 10, 12 years. Every single change they've made to it along the way. And you can see who contributed to change. Mapping that would probably be a full-time job, which would take somebody quite some time.
So if I go back to the DMCA, it's fascinating because I was up on the Hill negotiating that along with many other people. No one ever thought that it would be used for industrial software. It's really interesting. But the sort of question I have is trying to put on a Hollywood hat. Those cases are very narrow and don't have much applicability out of the specific facts. That indeed, had any of the protection mechanisms been used to protect copyrighted material that really was, you know, that even breaking it to get to something that's not copyrighted is a violation of the DMCA. And that's their very strong position.
But you still got the reverse engineering exception.
Well, I assume for a second that CSS, I don't know if you remember CSS, a content scrambling system that protects movies, right? That the Second Circuit found was protected by the DMCA. That I don't see how it could be done, but just take a flight of engineering fancy. That Lexmark was able to use that to protect their software, their control software in their little inkjet cartridge. Again, the view of the Hollywood lawyers is that case would have come out differently. That breaking of that, even though that particular work they were trying to get to is not copyrighted, it doesn't rise to the level of a copyright, so you could break it. They said you'd still be violating the DMCA.
I don't think that's. I don't think the question is about the sophistication of or the creativity of the lockout device. It's that there has to be a nexus between. The lockout device has to be locking out the only path to a copyrighted work, and that's the question. No matter what the device is, I think. I don't think you're going to get. If courts follow, and I do think they're going to follow some, I think there's going to be a consensus that is going to follow some substantial part of the Federal Circuit and the Sixth Circuit in terms of applying the DMCA in this kind of situation. And I just think that it's going to be that you got to have a nexus. You got to have an underlying copyrighted work. The DMCA is not going to give you protection to just put lockout devices to protect, unless there's a valid underlying work.
If I found a DVD that had a public domain film on it, I don't know that anyone exists, then I could
Yeah.
break that and I'd be all right under the Sixth Circuit and Federal Circuit.
Well, I don't know if
Right, there's got to be a copyrighted work that you're getting access to by circumventing.
No,
And I
I-
think that's the key to the Lexmark case, because the circumvention was not getting access to what Lexmark contended was their copyrighted work. It was getting access to use the toner cartridge in Lexmark's printer. So it was not, the end result was not getting access to a copyrighted work.
But yes, I understand what you're
Yeah,
saying, and
yeah.
but that's a very narrow holding. If the point that Hollywood's trying to make, and I
Yeah.
think this is an interesting matter, and I sometimes think they're right, even though I don't like agreeing, is that if you break it for one work, you've broken it for all. Now, in the Lexmark case, it was just protecting the Lexmark controls stuff. But if you had some sort of universal, like CSS is for DVDs,
Okay.
something universal, and your defense is, oh, well, I just was breaking it for this one disc that had a public domain movie on it, I think you lose that. In fact, Congressman Boucher is introducing the bill again this year to say that, to say specifically what you're saying, broadly scoped.
Right.
With respect to
Yeah.
Lexmark and Chamberlain, they're very narrow. It was not a universal protection.
Yeah, and I think we may be talking about two different provisions of the DMCA. One being it's a violation of the DMCA to do something, to break in. But it's also a violation to create a device that is primarily for that purpose. And I think
Yeah.
that's the
Yeah. Okay, if you're talking about that, I think you make a device that could be used, you make the device originally for a protected purpose to break a Lexmark chip. I don't think there's a violation if you on the other hand distribute it to other people and they use it to break on a DVD that has the same encryption device. Clearly, those people who have used it to break the encryption device on DVD have violated the DMCA. There would be a question in terms of whether you've done something from a contributory or inducement
I mean, I
point
would
of
argue
view.
that Hollywood would. And they
Yeah,
have.
no, and I think Hollywood is just wrong in that they are, and that they are thinking, they don't want it, and if because you're on the Hill more and you're more dealing with things from the policy point of view than I am. I'm just dealing with them after they've all been passed, and I got to go litigate them. But they don't want to hear about what the application would be into other industries or what the unintended consequences. They just want what they want to protect themselves to the max, and they've delivered the satchels of money to the campaigns last year, and so now they want what they think they're entitled to, and they don't want to hear about it. You're right, but yeah.
I believe if I can torture this hypothetical a little bit more. Let's say Lexmark, rather than having a snippet of code on their printer cartridge, puts a song, a jingle, a Lexmark "We're a Happy Company" song. They copyright it. They don't distribute it in any way, but the printer asks the cartridge to please decrypt this song and send it to me. If I don't hear the song, I'm not going to print it. So the song itself is copyrighted. The decryption is perhaps CSS or something that's relatively rudimentary, but the printer cartridge holds a copyrighted work and is being asked, and that copyrighted work is protected. So there's two problems with a aftermarket manufacturer. First, they have to break the encryption and access a copyrighted work, and then they have to distribute their aftermarket pieces of things with a copyrighted work on it.
I think, well, the Sixth Circuit in Lexmark, they have, remember, there's 3 judges. 2 of them concurred on, well, I mean, there's a panel opinion, there's a concurring opinion, and then there's opinion that's both concurring in part and dissenting in part. So they would have somewhat different views of how to attack that. I know Judge Merritt's opinion would say, get out of here, you can't do that. You're making 2 encryption devices. And I think 2 out of the 3 judges would probably come out that way here, because it's the point that I made where you can't just put some creative little piece into a program where it's just there for this whole lockout functionality. It doesn't have a function other than trying to protect non-protected works.
In other words, you've got to look all the way through to the end result.
Yeah, you have to have a creative functional program that adds utility to what it is, I think would be the majority. It's hard to parse through the opinions and tell you exactly what it is, but I think the majority of the Sixth Circuit, and the 2 stronger opinions really were Sixth Circuit judges. The one who was a little bit more for Lexmark was a district judge sitting by designation. So, I'm thinking probably that the stronger end of it would hold if you go back to the Sixth Circuit.
Just out of curiosity, who were the judges on the panel besides Merritt?
One of them is, I can't recall the name of the judge off the top of my head. I got it downstairs, but the Merritt was the concurring one and the strongest one and the most pro-competition in the way he came about it philosophically. The other circuit judge was the one who had a more middle-of-the-road panel and wrote the panel opinion. The dissenting judge was a district judge who's actually quite old. He's 88 or 89 years old, from Toledo maybe. And he apparently is a guy on the Sixth Circuit who's still reasonably active even at that age. And he's always been sort of a copyright guru within that circuit, and that's probably why he was sitting on that by designation. They took a very long time between the oral argument until the opinion came out. Clearly they were trying to reconcile these different views, and they finally just, because they all agreed on the outcome basically, but how they analyzed it was quite different. But I think you got to read those 3 opinions together and the Federal Circuit together to get, you're not going to get an exact definition of what's going to go on, but I think you're beginning to define the channel that the river's going to run in.
The Sixth Circuit has a history of very notoriously reversing panel decisions that turn out one way in copyright cases. I refer specifically to the Michigan Documents case, where the panel came out very strongly in favor of the copier in that case, and the en banc decision flipped it 180 degrees and followed the Princeton case. Do we see any indication that this is going to be asked for an en banc?
They did ask, and it was declined.
Okay.
And I wasn't so sure they were going to ask for an en banc because they got spanked pretty hard. But it was denied. The district court judge below was from Lexington, Kentucky. No surprise as to why it.
Yes, he wants to be able to go out and have supper with his.
Well, he's going to go to the country club and have dinner and play golf with those guys. So that's why you have a Circuit Court of Appeals. Mary, do you have any SAS positions on any of this?
No. I was just pleased to see that you got to the antitrust side of the issue.
Well, you knew I would eventually.
I know, I was making notes about 2 slides before you got there.
Robert, any comment from the?
I worked on the equivalent of the Millennium Copyright Acts in Europe, which is called Copyright in the Information Society. And we discussed the Lexmark case because it was just beginning to loom and we were lobbied on it. And we were saved from having to do anything specific about it by the fact that, first of all, we thought it was an antitrust issue, and that we could rely on the courts to be vigorous enough, the commissioner to be vigorous enough to pursue it. And secondly, because there was a weird bit of community legislation which actually prohibits making it difficult to recycle products, such as toner cartridges. So we sort of escaped without having to do anything.
I would think the Greens would be all in favor of that.
But certainly I agree with you. I don't think it's that simple, you know, that if they did use the music industry's encryption system, you'd have a problem. You know, would they be, by using that, say they bought it quite legitimately, saying, hey, it's a new use of your product, you know, what could you do about it? You know, is it against public policy? Don't know.
I think probably from a practical point of view that in an industrial environment with these kinds of products, you're just not going to have technological lockout measures or encryption systems that would be.
If you incorporate like the guy at the back said with a song, you know, you could say, you know, you can make this a feature of your product, you know, a new free pop song by an unknown pop group every toner cartridge. You can get every garage band in the States. You know, then you've got a problem, you know, because it plays back unless you turn the mute down on your computer. God, I shouldn't be doing my job really.
Any other questions or comments? Well, I think the hour for the reception is upon us, so let's adjourn.